Happening now, a high-stakes hearing for Luigi Mangione, the man accused in the targeted killing of healthcare CEO Brian Thompson nearly a year ago today. Mangione's lawyers are trying to get a New York judge to toss some critical evidence that investigators allegedly obtained when they arrested him at a fast food place in western Pennsylvania days after the killing. Prosecutors say the items in Mangione's backpack that tie him to the killing include a handgun, a loaded magazine, and a notebook with handwritten entries. The defense, though, says that police took those items without a warrant. Let's get some expert insight from criminal defense attorney Robert Bianchi, who's also a former homicide prosecutor. Bob, thanks so much for being with us. I wonder if you think Mangione's lawyers have a strong argument to make for this evidence to be tossed.
Boris, I know that people tend to do like balls and strikes here in terms of where your ideology is, but I look at it as an attorney, and from the beginning of this, I've been extremely concerned about the constitutionality of this search. Now, we don't know a lot of facts, but I've been on a lot of murder crime scenes where I see over-anxious and understandably well-meaning police officers in a heightened situation. They're not thinking it through. Maybe they're not in contact with their prosecutors or lawyers, and it's natural and instinct to just kind of open the bag and take a look-see to see what's inside. It happens all the time. And the defense is essentially saying here, the Constitution requires that every search be done pursuant to a warrant, a judicial warrant. And there are some exceptions to that warrant requirement. And the defense is saying there are no exceptions here. For example, if somebody consents to having the backpack looked into, then that's an exception to the warrant requirement. So I hope that I'm not going to hear that they just grabbed it, they were excited, they didn't have probable cause, they weren't in fear, they weren't in danger, he was secured, and they just looked inside and then afterwards got the warrant. In New York state law, that may be a problem. You have an easier chance under federal search and seizure law.
It sounds like you think that if this evidence is tossed, the state is going to have a hard time finding him guilty.
Wow, this would be a massive blow to the government. But then again, let's keep in mind here, we have both state prosecutions and federal prosecutions, and what may be suppressed in state court, again, federal court's more accommodating the prosecutors. But the evidence in that backpack, even though you don't need motive to prove a homicide case, shows premeditation. It's got the weapon. The weapon is connected to the victim in the case. It shows a cold, calculated, premeditated murder. It is the lock that any prosecutor wants. Otherwise, they got to go without that evidence on a circumstantial case that's much weaker. In that case, it's going to be interesting to see, really, to be honest with you, Boris, when the law enforcement authorities get together, there's got to be a discussion. Is it better to prosecute them federally first or better to prosecute them state-wise? Now, if there's a suppression of the evidence in state court, you can bet the federal case is going to take precedence.
I also wonder about the other evidence his attorneys are trying to suppress, and it involves statements that he made while at that McDonald's in western Pennsylvania. His attorneys are essentially arguing that officers didn't advise him of his Miranda rights the right way when they began questioning him. How do you see that playing out?
Not as crucial as the search and seizure, for sure, because that evidence in that backpack is the lock. But of course, if the prosecution wants to use his statements, Miranda requires that you, one, be in custody, or the person would have reasonably believed they were not free to leave. That's element number one, and that they're asked a question. So the issue in this case is going to be, and we just don't know the facts yet, was he in fact under the reasonable belief that he was not free to leave, and was he asked a question without being given his Miranda warnings? And if that happens, then any statements that he made up until the time he gave his Miranda warnings is subject to being suppressed by the court. But again, in this particular case, if I were a prosecutor and things were on the line, I'd rather lose on the Miranda side of the case and make sure I win on the search and seizure side, because that's where the case is going to be won by prosecutors, what's in that backpack.
Bob Bianchi, appreciate the analysis. Thanks so much for joining us.